Hello everybody and welcome to Alan History Nerd. Today I'm looking at US politics again. This is and this particular topic, interpretations and debates of the US Supreme Court and civil rights. So this is going to be a biggie because this is going to build on a lot of my previous videos where we've looked at issues of rights and all the ins and outs of different aspects of the Supreme Court and its view on its action on public policy and all those different bits. It's pulling it all together and looking at the really kind of analytical side of it. So in some of it, I'm going to be going back over some of the bits that I've talked about before, and I'm going to be trying to give you some guidance and push you in the different directions in terms of making some judgments and building what are likely to be the kind of essays and things that might come out of this. So this could, again, from the A-level politics specification, this looks at from component 3A, section 4.6, interpretations and debates of the US Supreme Court and civil rights, and it looks at the political versus judicial nature of the Supreme Court, the living constitution, ideology as against originalism, how effective civil and constitutional rights have been upheld by the Supreme Court, and the effectiveness of this protection, the extent of their powers and the effectiveness of checks and balances, the successes and failures of measures to promote equality, including affirmative action and immigration reform. As I said, much of these details have been covered in the earlier videos, so I might not go into quite as many really detailed examples as I have done in some of those. So it would be well worth going to my US politics playlist and working through the series of videos on the Supreme Court to build that kind of underlying knowledge of the cases and the ins and outs of how appointments work and what happens when there's a space on the bench and where there's been action in certain areas and where there hasn't, and the different views on interpretation, all those kind of bits. I'll look at some of it as we go through, but as you can see, we're looking at here really is a series of arguments. Now, a lot of these are enormously controversial in US politics, and they are therefore good things to look at because there's clearly two sides, and this is the essence of politics, isn't it, really, where we look at the real nuts and bolts of the debates. So I'm going to start off with the political versus judicial nature of the Supreme Court, and this bit in this lovely bright blue is looking at the political side. So this is the argument that actually the Supreme Court is a political institution. So we've looked at this before, and we've looked at nomination and confirmation and the appointment process. The nomination and confirmations are highly political. And if we look at the example of Trump and then the confirmation by the Senate of appointing Amy Coney Barrett versus the blocking of the proposed appointment of Merrick Garland by Obama 4 years earlier, being blocked by the Republican Senate, then we can see that this is just a highly political thing. So we see Republicans appointing conservatives, we see Democrats appointing liberals, and all of this seems to play into the idea that this is a big political game. The media really kind of gets its teeth into this and kind of like, well, this is a big change. This is seen as one of the great successes of Trump's four-year term, is that actually he got to make 3 Supreme Court appointments and therefore shifted the balance of the court, and the court is now 6-3 in favour of the Conservatives, and this is going to have a huge beneficial effect, some believe, in terms of on Conservative issues, in terms of the way that the Constitution is interpreted. So all of that, if one side or the other can get hugely excited, and one side is usually despondent about the appointment process and what's happened and the makeup of the court, then that suggests this is really a political institution, and really maybe rather than just using terms like liberal and conservative and loose and tight constructionist and things like that, we should just use the terms Democrat and Republican. Now, obviously, all of that it can be debated. The other bit that suggests it's a political institution is the judgments that it's made. So it makes key decisions on public policy. And again, this is my video on Supreme Court and public policy. So we have seen decisions on gun rights, on abortion, on LGBTQ rights, and immigration and healthcare, and all range of kind of really key political issues. The Supreme Court has even had a say on the election in 2000, the case Gore versus Bush. It had a say ultimately on the 2020 election, dismissing Trump's claims. And therefore we can see, again, the argument here is very clear. These are political issues. gay marriage and abortion and gun rights are political debates being held by the political parties. The fact that the Supreme Court is making the decisions on them rather than Congress suggests that the Supreme Court is a political body. There's also this key idea which looked at in previous videos, this idea of judicial review that essentially makes the Supreme Court like a quasi-legislative institution where it is acting like a third house of legislature. It is the case that we've seen justices in effect legislating from the bench, and that reflects, although the kind of issues that we've looked at before in all those different cases. There has been real tension on Roberts' court about this, because Roberts doesn't like the idea of judicial review. He doesn't like the idea of essentially the Supreme Court making the decision that gay marriage is legal throughout America. He thinks that decision should be made in Congress, not by the court itself. So even the issue of judicial review is a debate on the Supreme Court. But it looks political. It looks like what is happening is these decisions are being made. Now, there are critics of this idea that there's all this judicial review and judicial activism, and they say, well, actually, what's happening is the sides who don't like the results just call it judicial activism. But it is a really important part of that side of the argument. The counter argument is that essentially the Supreme Court is judicial in its nature. It's a court, that's what it does. So the justices are not politicians. Their credentials are based on their experience in the lower courts, particularly the circuit courts, or their academic knowledge and teachings and writings on constitutional law. Essentially, with most modern appointments, they make no reference, or the candidates try to make no reference to their political views on issues like abortion, because they've learned the lesson from Bork's nomination in 1987, when, having spoken extensively about his views on some of these key and very controversial issues, the Democrats then did everything within their power to block his route onto the Supreme Court. And so since then, they tend to not answer questions on that kind of issue. Another important issue in showing that it's a judicial branch is its independence from the other branches. So things like life tenure free the judges from political pressure, because they can't be held accountable by the executive or by Congress. They can't be removed easily. They can't be removed. They can't be essentially told off or kind of reprimanded for the decisions that they made. And therefore, whoever they've been appointed by, even if the person who's appointed them is still in office, then essentially once they've been appointed, they are completely free and independent of political influence. And again, a good illustration of that would be the decision made on the 2020 election, including by the three judges who had just been appointed by Trump in the term that had gone before, suggesting that great deal of independence. So these aren't political appointments that therefore have a degree of allegiance to whoever appointed them. They are appointment of experts, and that's why you have the American Bar Association kind of rating whether they are qualified or not qualified or well qualified. So these are qualified people to do a judicial job. Now, the other idea is that the justices actually make their decisions based on legal argument. So they might look at factors such as precedent, and there might be some issues that play into this, like originalism versus living constitutional activism versus restraint. But this is not political ideology. These are differing views on the Constitution and the role of the Supreme Court. So in that way, it's not political. These are judicial arguments. Now, if you're going to make a judgment on this, then a lot of it is going to depend on your view on a couple of really key bits. So, has the appointment process by a combination of the president, the Senate, and the media become an overly political action? And if so, you're likely to start to see the court in political rather than judicial terms. Is judicial activism, is that a step too far? Is that the court jumping into the political sphere? And then if you believe there has been a lot of that in recent years, then you would say that the court has become more and more of a political institution rather than a judicial one. Now, the arguments I've just been talking about, these conservative versus liberal, originalist versus living constitution, strict constructionalist versus loose constructionalist, all these are arguments that are had about amongst judges and other people about the way that the Supreme Court should act and how the Constitution should be viewed. Now, are these differences in judicial interpretation, or are these political differences? So if you can associate all those with all one side of those arguments with one political party and all the other side of that with the other political party, then, for example, if I look at a liberal who believes in the living constitution and is a loose constructionist, then if your mind then screams Democrat, and if I go, well, I've got a conservative who's originalist and a strict constructionist, and you'll just go, well, that's a Republican, then it looks like it's just political. If you go, well, actually, no, what you could have is you could have someone who is a mixture of those in terms of the way that they view the Constitution, or you could have someone who is not actually tied by when making decisions on that, they make them on that, even if the decision would have gone the other way for it to kind of to fit with what you would see as their central ideology. So they might, through being originalist, they might uphold some conservative ideas, where you might otherwise consider them to be a liberal judge, or they might, because they believe in judicial deference, then they might uphold precedent or acts of Congress, even though they would go against their conservative ideas. And we see this, for example, on occasion with Roberts. So if writing an essay on this topic, you need to have lots of well-selected examples. Again, I would suggest you go and look particularly at the video on the Supreme Court and public policy, and then the introductory videos that look at the appointment process, to make the judgments about, well, how political are these elements? And when you're giving examples, try to be as up-to-date as you can. So a lot of green here, because we're doing the living constitution, so I thought green was a good idea. Right, so living constitution ideology versus that of originalism. Well, if we're looking at the living constitution, then what the suggestion on this side of the argument is that the founding fathers deliberately made the constitution vague as to allow discretion on how it was applied in the future. So if you want to make something that is going to last a long time, there has to be a degree of vagueness, because things are going to change around it, and so for it to be able to adapt it has to be, in a degree, it has to be vague. And again, it's worth looking back on my videos on the Constitution itself to look at that, if vagueness is an important part or founding principle in the Constitution. The founding fathers envisioned a living constitution that the Supreme Court would apply the rules in an ever-changing context. So you always have to think, well, again, language is a great thing on this. If any of you are kind of students also studying things like English language, then you'll know a great deal about this kind of stuff. Is that words change their meaning over time. So when the Eighth Amendment was written in 1793, and they used the words cruel and unusual in reference to punishment, well, what would be considered cruel and unusual in 1793 is probably very, very different to what we considered cruel and unusual in 2021. When people were writing about liberty in the 14th Amendment in 1865, then that probably meant a very different thing in 1865 than it means today, and therefore the interpretations of these words should be updated according to those who favour a living constitution. And this then leads into the argument. It stops the Constitution becoming outdated and irrelevant, and there's many issues, therefore, that the founding fathers would never have even thought about, which have to be dealt with in terms of the Constitution of today. So issues that we've seen, such as gay marriage, therefore being required for the court to decide on the upheld versus Hodges, and then there are others, but this is a really good example, because it showed the division on Roberts' court, particularly in terms of an idea of living constitutional versus originalism, where they're kind of going, well, it's not there, so you do you adapt, or do you do the kind of the due deference to the other institutions and go, well, there's nothing in the Constitution on this, so we can't deal with it. It needs to be dealt with by Congress, which is what Roberts would have favoured. Now, judging the actual views, according to those who favour the idea of a living constitution, and more in particular the intentions of the founding fathers, is a subjective thing. It's just as subjective as any other process in making decisions on how to apply the constitution in the modern context. So how would the founding fathers have felt about the application of the Second Amendment in DC versus Heller in 2008, saying that it was allowed for self-defense? Well, it doesn't say that it's explicitly in the Constitution, but some judges felt that that's what they intended. Well, you can argue is as subjective as those who say, well, it's not. It shouldn't be made in the current context. Can originalists be any more certain that the founding fathers intended that self-defense than those who said they didn't? Well, I don't know. So and we'll see this when we look at the counter argument. The originalists are going to claim, well, they are the more objective attitude towards the Constitution, but this is the attempt to undermine that point. So on the side of originalism, the court should not be able to impose its own values, its own social political values on the Constitution and disputes over its position. This charge is often made against any court that carry out judicial activism, so the Warren Court, for example, but often by any decision made by the Supreme Court which is controversial, which a lot of them are, and where you have differing political views on them. On issues not covered in the Constitution, then decisions according to those who follow originalism, then the decision should be made by the elected branches of government. And again, we mentioned this. Obergefell versus Hodges, we mentioned this. Roberts raises this in his dissent, where he kind of goes, it's not in the Constitution. It's not for us to make this decision on it. It should be done. It should be set by Congress, not by us. Now, originalism, again, the counter-argument to what we looked at a minute ago, originalism is objective, it is argued, because it's looking firstly at the words of the Constitution, and if it's there, it's there, and only at the intention when the meaning is not fully clear. And then we come to this idea of vagueness. And then it goes, well, any decision to fundamentally alter the Constitution or the way it's interpreted should not be dictated by fads and social belief. So if society becomes more liberal, then that might reflect more liberal laws. But if they're going to change the Constitution, then you need to go through the amendment process and things like that. It shouldn't be the Supreme Court's view to go, the people are becoming more liberal, we'll become more liberal. The people are becoming more conservative, we will become more conservative in the way that we see the Constitution. So, and it suggests that these short-term shifts, or fads as it might call them, in belief about things in society, shouldn't then be transferred into a kind of semi-permanent way in terms of the way the Constitution is viewed. So, putting all this together, I mean, there are a range of types of questions you could be asked on this. So you could be asked which is the two is used most. So evaluate the view that originalism plays a key role in Supreme Court decisions. And in that, you would look at a series of cases and go, well, in this one, that looks like originalism, and that one looks like living constitution. I suggest, again, you go back through my public policy, Supreme Court public policy video and make sure you can pick those out and go, well, that one is that and that one is that. The other question is kind of the debate we've just looked at, which of the two is more valid, and we've kind of looked at 3 points on either side on that. So evaluate the view the Supreme Court's interpretation of the Constitution needs to be regularly updated to keep the Constitution relevant in the US. And so that would be the kind of statement there is arguing in favour of a living constitution. The counter argument should be no, it shouldn't. It shouldn't be regularly updated. We should stick to the original words and the original intention, and we leave it to the other elected bodies if any changes are needed. Now, this next one looks at how effectively civil and constitutional rights have been upheld by the Supreme Court and the effectiveness of this protection. Well, there are a whole range of things that uphold rights in the US, and again, this then reflects different ways you could look at it. So you could look, well, actually, the rights in America they're upheld by the Constitution. So we have the Bill of Rights, and that has got the First Amendment, that looks after speech and freedom of religion, and we've got the Fourth and Fifth rights that look after the rights of the accused. We've got the Eighth Amendment, looks against protection from cruel and unusual punishment. You've got the Second, which guarantees the right to bear arms, and all the different bits which come out of the first 10. You then have a series of other amendments which have played a really key part in building rights in America. Now, I think, and again, it's worth looking back at some of my earlier videos on this, I think the 14th Amendment is probably the biggest on this. And I look at this when I look at rights in the US. The 14th Amendment plays a massive role, as does the 15th. So you could say, look at it and go, well, actually, the Constitution through this, they protect people's rights. Now, fitting in with this, you've got, well, it's actually the Supreme Court that does it, because they've made a whole range of decisions on issues that affect the rights of Americans. So, for example, on abortion, you've got Roe versus Wade, you've got Whole Women's Health versus Hellerstedt. On LGBTQ plus rights, you've got Bostock versus Clayton County, and Upheld versus Hodges. You've had a protection on unwarranted searches. Again, you can see that in the Bill of Rights, but you can also see that in Riley versus California, where it's applied to mobile phones. You've got gun rights, because yes, it's in the Second Amendment, but also you can look at cases like DC versus Heller in 2008, and kind of that judgment overturned the laws in DC about having handguns in the house. So you've got a whole range of this where you can actually say, well, the Constitution sets out the rights, but really it's the Supreme Court that comes in and protects them, and kind of goes, right, that institution or that bit of government is infringing on people's rights to do that, or fundamentally people have this right. And therefore the Supreme Court is the kind of protector of rights, the designator of rights in the US. There are, however, some other kind of key bits you would need to think about. So some of the rights in the US don't come from the Constitution or the Supreme Court, they come from acts of Congress. So you could look at the Civil Rights Act of 1964, the Voting Rights Act of 1965, and they attach to the 14th and 15th Amendments, but they kind of fill it out, and they develop the rights that are in place. You could look at the Immigration Acts, like the DREAM Act, obviously didn't get through the Senate, but we've seen a series of actions following that by Obama through executive order and things like that with DACA. You've got the Affordable Care Act, which is to do with rights of access to health care. You've got the Race to the Top Act in education, about rights to education, No Child Left Behind. If you go back to Bush, similar idea in terms of a fundamental rights for education. So you could say, well, a lot of the rights come through the president's actions and by acts of Congress. I mean, some of it can just be other forms of government action. So my Brother's Keeper initiative, aiming at removing some of the opportunity gaps for young black men. The annual White House Tribal Nations Summit. And there's a whole range of stuff that the state and federal government can do that can build the rights of US citizens. There's also all the actions taken by pressure groups and other organisations, so non-governmental organisations who are doing things. So probably the most famous influential of these groups historically has been the NAACP, which is still going very strong today. So they have a long history of campaigning on rights issues, on using the courts to protect rights. There's still ongoing from the NAACP, the Moral Monday protest in North Carolina against the changes in policy that have been instituted there by the Republican Party and that the NAACP believe are damaging minority rights. We've seen the Black Lives Matter movement that's raised awareness and led protests against discriminatory action by those involved in the criminal justice system, and the statues and things that commemorate the Confederacy, and trying to kind of highlight this as a damaging part of culture in the US. There are other organisations like the NativeVote.org that's campaigned to raise political participation by Native Americans, so therefore then build on and ensure the protection of their rights. And then we saw, for example, a huge range of grassroots organisations they played a really important role in registering and getting out the black and Hispanic votes in the 2020 election, which I believe had an enormous impact on the ultimate result. So you could get a question on which of these many different groups that I've highlighted in the bold, the pressure groups, the Acts of Congress and Government Policy, the Constitution itself, or the Supreme Court, which plays the biggest role in protecting rights in the US. Or you could get a more specific Supreme Court one, where you look at numerous decisions that the Supreme Court has made. And whilst you can argue some of these decisions actually furthered rights, you can argue some of the others actually eroded them. They eroded voting rights, or they eroded gun owning rights, or whatever. There's a whole range of them that aren't necessarily as positive as you say. There's some of the more recent acts decisions over abortion seem to be, again, limiting decisions to an extent. So we've got a whole range of these. The Supreme Court plays a really active role when it comes to rights. Is it always promoting them, or is it sometimes not? This next bit, we're looking at the extent of their powers in terms of the Supreme Court's powers and the effectiveness of checks and balances on the Supreme Court itself. So first of all, the Supreme Court has a significant range of powers. So the sovereignty in the US system lies with the Constitution, while sovereignty in the UK lies with Parliament. In the US, it lies with the Constitution. Now, because it's the Supreme Court that interprets the Constitution, which we've talked about earlier, is often seen as being rather vague on many issues, or not covering them because they hadn't thought about it back in the 18th century, then this gives the Supreme Court a great deal of power. It is powerful because it can overturn the actions of the executive or of acts of Congress that it deems to be unconstitutional. Obviously, it needs to be brought to it first, but it has that power to overturn these actions. Now, using judicial activism, essentially the court can legislate from the bench, and therefore we can see the whole range of things like abortion and gay rights that have actually got the key parts of them, and where they are is being decided by the Supreme Court rather than by any other of the branches of government. And you will see accusations by both sides about various courts legislating from the bench, whether essentially they are making law rather than Congress doing it. Now, the independence of the court is strongly protected, and we talked again about this if you go back through the process of appointment, but also look at the protections that are built in there. So life tenure, for example, defends the independence of the court. Now, you can overturn Supreme Court decisions, but to do that, you either need a later Supreme Court to decide that Supreme Court got it wrong, or you need to use the amendment procedure. Amendments are incredibly hard to pass. Again, since we're on the issue of rights, you got the ERA, which was an amendment to promote equal rights for women, and it just never managed to get through. And then there's now a court battles going on where we've had late ratification, and which goes beyond the time frame set by Congress. So if there is going to be a change over a Supreme Court's head, then it's going to take the amendment process. The amendment process is really hard, so therefore a lot of power lies with the Supreme Court. Now, the counter to that says, well, actually the Supreme Court can give up, that we've got some really strong checks and balances on it, is, well, the court is restricted to the power given to it by the Constitution and the wording of the Constitution. So it can't go beyond that on the vast majority of issues. It can only deal with constitutional issues, and it can only deal with those when they are brought to it. It can't initiate something. So the 9 Supreme Court justices can't sit down one day and we go, well, their government's done that and we don't like it, we think it's unconstitutional. Someone would have to challenge it. It would have to go through the courts. So the system would end up with them, or they would have to bring it directly to them. The appointment process, the amendment process, give 2 means for Congress, and particularly the Senate, to check the power of the Supreme Court. And if justices themselves believe in judicial restraint, then that acts as a massive check and balance on the power of the court, because they will look to and give deference to the elected branches, and they will look to precedent, and therefore effectively reduce their own power. So if you have a court that believes in judicial restraint or judicial deference, then the court's not going to act in a particularly powerful way. In this next bit, we're looking at the successes and failures of the measures to promote equality, and I'm going to do two of these. I'm going to look at affirmative action, and then I'm going to look at immigration, which are the two, again, highlighted in the spec. So affirmative action, I think, is a really tricky one. So you can argue it has righted some of the wrongs of disadvantage and prejudice. So Sotomayor, one of the Supreme Court justices, has said that actually her career, and it started with her getting her place to study law at university, and that goes down her place. She believes affirmative action played an important role in that. So what you can do is you see a promotion of success amongst the minority groups which have previously really struggled to gain that success being helped along by affirmative action. So that can be seen as a real positive. It has increased diversity in institutions such as top universities and top firms, and even as far as we look at what you could argue with Biden doing at the moment in terms of a cabinet. And the whole idea behind affirmative action is to promote equality and reduce racism, and you can say this has been demonstrated to be successful by the election of Obama 2008 and 2012, and the election of Harris in 2020, amongst improving representation in both houses of Congress as well. And diversity is an important part of this, and the idea is that as institutions and America, and diversity is promoted through America, then as people get to know and meet people from more diverse backgrounds, then a lot of the problems of racism and prejudice will be defeated and will go away, and that affirmative action is starting to help steps in that direction, and therefore it is doing what it has set out to do. On the counter to that, there have been failures. I mean, it's definitely the case that affirmative action has faced failures as well as degrees of success, but mainly I would suggest failures in terms of cases in the Supreme Court, such as the University of California versus Back and Schuette versus the Coalition to Defend Affirmative Action. So again, it seems to be on the back foot and receding in importance. So, for example, now in Michigan, they've kind of said we're not using it. Now, the other argument is more philosophical about this. It really goes, well, actually, a policy that distinguishes based on race is unlikely to lead to a society where people don't distinguish on race. So actually, essentially, there's a philosophical flaw in the centre of affirmative action where, well, and this then leads into all kinds of resentment and backlash and things like that. How are you going to convince people who haven't been given a fair go based on race that what you're going to do is potentially disadvantage them by giving other people a leg up or a helping hand based on their race? So that is a bit where a lot of justices on the Supreme Court and others in America and politicians have really tussled with us on this and go, well, actually, there's something in the centre of this that isn't going to mean it's a long-term solution. It might well have been helpful at the end of segregation and all the issues that the civil rights movement exposed, and then it led to change, and then that change didn't bring enough change in itself, and therefore you needed an extra push, an extra helping hand to move things forward. But it's not something that can be permanently there. It's internally flawed. Is the side of the argument. You might this is one of the joys of the politics of this. You can completely disagree with that. You might look at the successes in green and build on those. You might look at these failures and go, I think that's a really important point. Now, again, I think this bit's a bit controversial, but there was a study in the Stanford Law Review that actually looked at student places that had been given on affirmative action and suggested statistically that those students were struggling in comparative to their peers whose places didn't owe anything to affirmative action. And therefore, actually, what you're doing is you're putting people on courses that they aren't necessarily 100% suited to be. Again, a viewpoint that has been expressed. Okay, one of the bits when I often talk to my students about affirmative action, we talk about, for example, the widening participation policies that you see in British universities about with students who haven't got a family history of people going to university, or based on postcode or household income, and the helping hands that be given there. Again, I would be interested to see studies on the impact of that in the UK. Now, this next one is immigration, and again, immigration is a hugely controversial issue on America, and it's difficult ones for you to find kind of particularly objective stuff that goes down the middle, and then it doesn't just turn into a shouting match in terms of the argument on either side. Now, it is a highly debated issue. Over Trump's 4 years in office, then we saw the big push to build the wall, and we saw the arguments about who was going to fund it, and then continuing arguments about how much of it has actually been built and whether it's made any difference or not. But Trump's aim was to restrict immigration into the US, particularly from South America and particularly from Mexico, and then also there was aims to reduce the number of asylum seekers and particularly travel bans, trying to prevent people entering the country from Muslim countries as well, which again was then challenged, and we saw a whole series of stuff through the courts with that. So before Trump, we had Obama. Well, Obama had a very kind of different approach. So we had the Development Relief and Education for Alien Minors, which is often referred to as the DREAM Act. And the idea of this and this idea of dreamers is trying to create a route for non-documented immigrants, particularly those who entered the country as children, to citizenship. And the DREAM Act failed to pass in the Senate, and therefore you got executive action by Obama, especially through executive orders, and we got him setting up the DACA program, which is Deferred Action for Childhood Arrivals. And again, there has been some success in that, and it was aimed at trying to prevent deportation of people back to countries that either they had never set foot in, or they hadn't since they were children, and they had no memory of. And again, then we saw Trump trying to attack the ideas of birthright citizenship as well. Actually, it shows so children. The difference in here is children born in the US, even if their parents are not there legally, they are born in America. So according to the 14th Amendment, they are American citizens. Whilst the childhood migrants, they don't have birthright citizenship. Now, you could argue they've not deliberately broken any laws or anything in terms of getting there. They've been taken there. They've grown up there. The only place that they know as home is America, and there's been a whole protest movement that's grown up around this idea of the dreamers and trying to protect the rights of these individuals. And it is estimated on the positive side on this, in terms of the action of DACA and the DREAM Act and the Dreamers movement, that if you could get the undocumented migrants in the US properly on the books, so to say, and you could give them a line, a channel into full-blown citizenship, then this would have a huge benefit for the government, because they would start paying federal taxes, and actually they already work and contribute to the economy, so they could then be on the books, and they would not be being exploited in the same ways because they're on the books, and then but they would also start paying tax. So all this helps the economy. And the argument of this idea that you go around removing all these people from America is nonsensical, in terms of what you're going to do is you're not only removing people who are doing a lot of important labour in the States, but you're also then removing all the money that they spend. So you are damaging the economy, as well as the other issues surrounding the ideals for or against having the people there in the first place. So Trump reversed everything that Obama was trying to do, really. So he reversed Obama's executive orders on immigration, including ending the DACA program. There was a bipartisan DREAM Act in 2017, but that failed to get through Congress. Trump's term saw these huge controversies over immigration, with children being separated from their parents and use of detention camps, which was all part of a zero tolerance policy on people crossing the Mexican border. Then taking it to the next stage, and we've seen Trump's executive orders regarding immigration have now been overturned by Biden. It's one of the first things Biden has done in his term in office. Now, the exact shape of immigration legislation is not 100% certain, yes, but it's likely to be very similar to the policies of Obama. We've seen immigration as being used as an issue where Republicans of the Senate have been looking to slow or block appointments to Biden's cabinet. So again, we can still see this is a really hot issue and one that really divides Republicans and Democrats. Well, and this is one of the things that makes this really hard. So what is success in immigration policy? Well, if you ask a Democrat and a Republican, you get completely differing views. So Republicans would say, or a lot of Republicans would say, not all Republicans, but a lot of Republicans would say, particularly those who are in line with Trump, the success in immigration policy would be a massive reduction in immigration and then the forced removal of those who were in the US illegally. The net result of this would be the percentage of native-born Americans would go up, and the percentage of non-native-born Americans would go down. Trump spoke continuously about all illegal immigrants as being criminals, and him and those who support him in the Republican Party have a really clear nativist agenda, which means that they're looking to kind of block further immigration. This doesn't mean they're protectors of Native Americans. It means that they're protectors of what are often referred to as the WASPs, the white Anglo-Saxon Protestants, the early phases of immigration, and kind of going, these groups are now being disadvantaged by these new groups who are coming in. There is all kinds of accusations of stuff to do with racism, all sorts around this. It is a highly, highly controversial issue, particularly because the Democrats' view of success looks like completely the opposite. So success for the likes of Biden and Obama in terms of immigration policy would be that there was a solid and positive route towards citizenship for essentially the undocumented migrants who deserve this route. Getting these undocumented migrants on officially full-blown citizenship would boost the economy, would boost tax revenues, would end exploitation, and would fit with the ideas, again, if we go back to the Statue of Liberty and the famous words, "Give me your tired poor, your huddled masses yearning to breathe free." And it would go back to that ideal, which is not the ideal which Trump and his supporters are putting in. So if you are looking at a Republican view on it, you want to see immigration numbers going down, you want to see deportations going up. If you're looking at it from a Democrat point of view, then you are looking at kind of proper processes for people legally entering the country and through high numbers of undocumented migrants becoming dreamers and gaining citizenship. So again, a controversial debate and one where you can find arguments on both sides. I hope that's been helpful for you going through all those debates. Again, in terms of some of the kind of the details in the individual cases, well worth looking back on some of my previous ones, particularly those that are addressing rights in the US and those that are dealing with the Supreme Court and public policy. If this has been helpful for you, then please hit the like. If you have any comments or questions, then please stick those in the comments section. If you haven't already subscribed to Alan History Nerd, then please do. There is a whole range of videos on both US and UK politics, particularly focusing on the A-level Edexcel specification as I teach it. And there are also a whole range of other playlists on there looking at various elements of history, including some US history, some British history, some Russian history. So lots of really good stuff on there, I hope. So hit subscribe, get notifications as we add more videos. Thank you very much for watching.